When you hear cod wars, you probably picture ships clashing on the high seas. But behind all that drama, a totally different battle was going on. This was a war of words, of documents, of legal arguments. We're going to dive into that whole legal saga, told right from the official records of the World Court.
See, this isn't just a story about fish. It's way bigger. It's about a clash between a nation's survival and the rules of the whole world. It's the story of how Iceland decided the best move in the world's highest court was to, well, just not show up at all.
I mean, we've got these international laws, we've got these courts, but what's their actual power when a nation just looks at them and says, nah, we're good? This is a serious legal drama, and it all kicks off with a fight over fish.
So, how did things get so heated? Well, it didn't start with a bang. It started with an announcement. Iceland basically said, we're expanding our control over the fishing grounds around our coast. And just like that, the fight moved from the cold Atlantic waters right into the courtroom.
Okay, so at the very heart of this entire mess is this one concept: fisheries jurisdiction. It's all about who gets to make the rules, right? Who says who can fish where, and how far out does that power go? For a country like Iceland, an island nation, the answer to that question was literally everything.
So when Iceland made its move, they weren't just grabbing more ocean. For them, they were securing their economic lifeline. In their official letters, they said it again and again. This was about the vital interests of the people of Iceland. This wasn't some political game to them. It felt truly existential.
Now, as you can probably guess, other countries that fished in those same waters, especially the UK and Germany, saw things a little differently. They were convinced Iceland's move was totally illegal, and they knew exactly where to take that complaint, straight to the International Court of Justice.
And they did not hang around. The UK followed their case on April 14th. A little over a month later, bam, Germany submits their own application. The legal pressure was building, and it was building fast.
For the UK and Germany, this was all by the book, just following the established rules. It's a pretty straightforward process. You file your case, you name your lead lawyer, they call them an agent, and then the court lets the other side know they're being sued. But yeah, Iceland was about to make things really, really complicated. And this is where the story just takes a massive turn. Instead of hiring their own agent and preparing a defense, Iceland sent a letter. And this letter basically sent a shockwave through the whole international legal world. They were refusing to play the game at all.
Okay, so here's what it all boiled down to. The UK and Germany were like, look, we have this 1961 agreement that clearly says the court handles these disputes. But Iceland's whole argument was, that was then, this is now. They claimed that circumstances had changed so much that the old agreement was basically null and void. We're talking two totally opposite readings of the exact same document.
And they were not subtle about it. This quote from their foreign minister's letter is just, wow, it's so direct. They respectfully told the court that on this one issue, their fishing rights, they just don't accept its authority. Period. End of story.
But wait, the letter didn't stop there. After laying out all their legal reasoning, they delivered the procedural knockout punch.
And there it is, the bombshell. They weren't just arguing about the court's power, they were boycotting the entire thing. No lawyer, no representative, no defense. Just an empty chair where their legal team was supposed to be. And that created a huge problem.
So this raises a pretty fascinating question, right? Can you even have a trial if the defendant just refuses to show up? Does the whole system just grind to a halt?
Well, the UK and Germany didn't seem too worried. They wrote back to the court and pointed out that, hey, the court's own rulebook actually has a plan for this exact situation. Iceland's boycott was dramatic for sure, but it wasn't a checkmate.
And this is where Article 53 comes into play. It's basically the legal safety net that stops a country from killing a case just by ghosting everyone. It says, if you don't show up to defend yourself, we can go on without you and make a decision based on the evidence we do have. The trial was back on. So, with the case officially moving forward even without Iceland, the UK and Germany immediately asked for an emergency ruling. Their argument was that waiting years for a final verdict would cause them real, irreversible damage.
You can think of this as asking for a temporary restraining order in international law. The UK was essentially saying, Your Honors, we need you to hit the pause button. Iceland's new rules are going to wreck our fishing industry right now, so we need you to preserve the status quo until this is all settled.
And on August 17th, the court made its decision. It was a compromise.
It told the UK and Germany to scale back their fishing to specific limits, but, and this is the key part, it also directly ordered Iceland not to enforce its new 50-mile limit. This was a direct command from the World Court.
So, the ball was back in Iceland's court. They had boycotted the process, but the process kept going, and now here was a binding order. What would they do? Would they finally play along? Would they compromise?
The answer came the very next day, and it could not have been more clear. This telegram from Iceland's prime minister was the final defiant word. They didn't just disagree, they strongly protested it and flat out said it was not binding. They had ignored the process, and now they were ignoring the verdict. Which leaves us with this huge question. What is the real power of international law when a nation, convinced its own survival is on the line, simply refuses to listen?